This is Halleck Hoffman speaking from the Center for the Study of Democratic Institutions in Santa Barbara. The center was established by the Fund for the Republic to study whether and how a free and just society may be maintained under the strikingly new political, social, economic, and technological conditions of the 20th century. Robert M. Hutchins, chairman of the center, recently described to an audience the center's method of study through dialogue and discussion as follows.
The Center for the Study of Democratic Institutions is a group of men meeting continuously and trying to think, I will not say how successfully, about the most urgent problems which, in their opinion, now confront us. The purpose of the organization is not merely to think, not merely to try to think together, not merely to offer a model of an intellectual community or to suggest how the dialogue may be carried on and the civilization of the dialogue achieved. The purpose of the center is to try to clarify the most important issues that we now face and to try to get these issues discussed by those who may in some way or other determine what shall be done about them. Every day at 11 o'clock, one of the staff or a visitor, of whom we have some 300 during the year from all over the world, is required to present a statement, is required to subject himself to cross-examination, and then he's required to go out and think it over. We do believe that we confront a totally new world. We believe that the rate of change is unexampled. We believe that it is only by taking thought that we may hope to save the West and perpetuate those ideals of freedom and justice to which we are all dedicated.
During 1963, the entire summer was devoted to the center's continuing study of law, jurisprudence, and the Bill of Rights. The broadcast that follows is one of 4 seminars held to consider a theory of the First Amendment proposed by Joseph Tussman, professor of philosophy at the University of California at Berkeley. Mr. Tussman, who is preparing a book on the subject tentatively titled The Government of the Mind, suggests a theory that reads the First Amendment as protecting and encouraging the active participation of the citizen in political affairs. Since government already assumes responsibility for protecting the body of the citizen, as through pure food and drug laws, weights and measure specifications, and so on, why, asks Mr. Tussman, should it not also assume similar responsibility for protecting the moral and intellectual development of the mind? In the same sense that officials like congressmen are guaranteed access to forums and are protected from the consequences of speech, so too, argues Mr. Tussman, should the citizen be offered protected opportunities for communication. Pursuing the analogy, Mr. Tussman then concludes that, having thus immunized the citizen from the consequences of his speech, the government would then have the right to inquire into the state of his mind or thinking, where such inquiry serves a public function. In the meetings preceding the one that follows, Mr. Tussman had defined speech as aggressive in character and therefore, because aggressive, subject to regulation. Subsequently, Mr. Tussman modified his definition of communication as aggressive activity, but maintained that where it possessed aggressive characteristics, his argument for regulation held as it now holds in laws that limit speech in cases of libel, slander, obscenity, and so on. Further, Mr. Tussman suggested that while the freedom to speak implies also the freedom not to speak, the right of silence is not absolute, as when a witness to a crime is called upon to testify. Although many participants were sympathetic to Mr. Tussman's proposition in general, there was sharp dissent on the particulars. The chairman, Robert M. Hutchins, reflects this dissent when he opens the meeting with a terse caricature of Mr. Tussman's proposition and follows with a suggestion for phrasing the proposition differently. Mr. Hutchins is followed by Mr. Tussman. Also participating are Harry Calvin, Jr. of the University of Chicago Law School, Philip Selznick of the University of California at Berkeley, and staff members Harry Ashmore, Richard Lichtman, William Gorman, John Cogley, and John Wilkinson. And now, Mr. Hutchins.
Mr. Tussman says, I take it, that the norm is silence and the aim is order. That is that really you have to show that you have a privilege to speak in view of your peculiar function or the peculiar circumstances of the time. Now, how would you like to say that the norm is communication and the aim is learning, so that the privilege is a privilege to remain silent under special circumstances rather than to speak? In fact, there is always a moral and sometimes a legal duty to speak. There's a legal duty to get your children ready for communication by sending them to school. There's a legal duty to talk if you're a witness. And the privilege is the privilege against self-incrimination, for example, the privilege to remain silent. My question is, doesn't this get you into fewer difficulties, and isn't this more in conformity with the kind of conception of the common good that you entertain than the opposite? The common good, I suppose, is the good of the community, but it is also the good of every individual in it. And one of the principal things that he can derive from being a member of a community is that he can learn from the other members. This then would become the aim, in a manner of speaking, of the political community and the principal component of the common good. Order being a necessary condition, but no more the aim of the state than, let's say, survival would be the aim of the state. This is a necessary condition, but is not the purpose of the political community.
Well, I wouldn't want to disagree with all of that. But I started out deliberately with a stress on communication as aggressive activity or aggressive behavior. I guess my own motivation was to show that the heavy concern for the control of communication activity isn't an anomaly. What I wanted to stress was, one, the positive problem of providing a forum, of providing opportunities to speak, significant opportunities to enter into the communication system. If you analyze then the notion of opportunity, it turns out not to be just the physical occasion on which one can talk, but to a certain extent the immunization of the communicant or the person involved from some of the consequences which have normally attended on communication, because it has this hostile, aggressive impact. So I guess the emphasis may get warped initially by the stress on the protections which are needed, which go beyond simply the providing of an opportunity for the existence of a forum and access to it. But if the suggestion, however, goes beyond that to the notion that a person has a right to say whatever he wants under any circumstances, and then very grudgingly apply restraints, would we, I take it, your question maybe, wouldn't we be better off with that, which I take it is the more traditional?
Yes, I was trying to avoid the use of the word right, trying to imagine a group of people coming together to form a political community. What do they do it for? Well, they do it for various reasons, but the one reason I think you would agree is that they can learn how to maintain order, they can learn how to be free, learn how to establish justice. If you start on this line and don't talk about rights, you come out almost with a set of duties rather than rights or privileges. And in this way you may also escape the discussion of such subjects as natural rights or even natural law if you feel like it. Harry, you were going to say something?
See, at times it seems to me that it's just a question of which is the rule and which is the exception, and you were partly involved in saying that we've always thought the exception was regulation. You now wish to turn the thing upside down and say, let's look at the opposite of that in a way.
Well, of course, I think we have to remind ourselves, I accept the stress on the objective, which has to be brought in, that the aim, a healthy system of communication isn't described in terms of silence in the end. On the other hand, once you start considering the communication situation, the problem of protection begins to loom so large that it led me, at least, to start with the other assumption. And once one does that, one finds, I think, as I did, that the norm has always been communication or speech as a form of aggressive activity which falls within the general area of controllable action, out of which we've won for instance, as a result of the theory and the development of the concept of criticism and the use of the notion of privilege, areas of freedom. Now, I acknowledge the inadequacy of the notion of privilege, which I used in a non-technical, narrow sense, but used it because it did have a suggestion of what the idea was, and I'm going to have to hunt around for something that's better than that. I think the duty
is this problem of the aggressive nature of speech. It immediately suggests that you regard the aim of the political community as order primarily.
No, yeah, well then if that's the case, that's not my intention.
What you're trying to do is what's the reason for regulating speech? It is that it's likely to be disorderly or promote disorder.
Well, he says, what's the reason for not regulating? It seems to me that there's a trick to, or any freshness in the formulation is really to turn your question around, which is taken for granted as being the right question. What's the reason for regulating? And saying, well, let's look at it the other way around. What's the reason for treating it as being beyond regulation?
Yeah.
And what I'm wondering about, does anything come from that? Is that just a kind of interesting rhetorical game between the two of you? Is that consequential, really?
I want to answer Harry's question just very briefly, in fact, in 3 words. It's a matter of the burden of proof. That is it a matter of no importance that when a question regarding speech arises, the burden is on the regulator to show that there is some legitimate reason for this regulation?
Well, I think I'd be willing to sake of seeing where it takes me, to argue that it doesn't make any difference. I mean,
Does not make any
that
difference.
the burden of proof only matters, talking legally for a moment, when the thing is close. Rhetorically, it makes a difference, as I don't like that any more than apparently you do. I find it almost hard to say the words. I mean, I don't like the formula. It offends my ear, but I don't know if it offends anything else.
I couldn't get into the argument if your standing rule against the use of the term right holds, but if you withdraw that rule, I would like to argue that it makes a lot of difference where you begin. How about that rule? Can I use the word right?
This wasn't a rule. I was merely, I'm a little afraid of getting into that discussion, but I don't, if you find it indispensable, please get into it.
Well, it seems to me then that
Mr. Gorman is here addressing himself directly to Mr. Tussman.
your syllogism was speech is aggressive. Anything aggressive is regulable, therefore speech is regulable. However, for certain social purposes, freedom rather than regulation may be allowed certain types of speech if a case can be made that that speech, thus privileged, will serve that social purpose. Now that didn't seem to me too unfair to the structure at one moment of your thought. I interpret you further now, this is not in terms of anything you said, as starting out sort of seminally with a deep dissatisfaction with a sort of absolute view that freedom of speech, any whatsoever speech, is the essence of the First Amendment idea. I would share your feeling that you can get nowhere with the notion that speech without any further discrimination is the thing that is the object of the First Amendment concern. It could be that good speech and bad speech is the issue. But the issue for me of the First Amendment would have to be in the middle between defining speech, what I would call abnormatively, as something aggressive, which seems to me, as I said to you, a poor thing to do, between that extreme and the consequences that what should be a right with regard to good speech turns out to be a privilege granted by the social and political process, which is abhorrent to me because I think there is a right that can be grounded by reason for freedom, for good speech that is not a grant by the state or the social process and so on. But I say this middle, just one more word about it, I say this middle is, the discrimination is about good and bad speech, and the case for the freedom is the case for the personal and social importance of good speech. The case against regulation is a case directed at bad speech, and we don't escape that discrimination about what speech is good and groundedly so by good reasoning and what speech is bad and so on. And I say that's in the middle between, repeat, an absolute, as so to speak, licentious view of speech and your abnormative view of speech, which has you ending up calling even what I think of as the right to good speech that is pre-social and pre-political as being a privilege granted by the state because of some social purposes it deserves. I don't know if that...
Well, I'd like to say something about that, but before I get into the major remark I want to make, I'd like to point out that even if you accept your distinction between normative and abnormative thing, that what you would call good speech requires a great deal of administrative provision. That is, the providing of occasions for speech, and even you'd find would require the problems of freeing a person engaged in it from some of the consequences. But now coming back to your main point, right.
Meaning, I don't, by freedom of speech, freedom for good speech, I certainly do not mean to deny even an obligation on the part of the state in the light of the existence of that right to facilitate the exercise of that right.
But now with respect to the basic distinction, if you remember, I started out with the notion that communication as a form of activity is peculiar or distinguished because it does involve mind-to-a-mind business, and that it's a kind of a mental act in a sense. And then immediately got off into the aggressive aspects of it. Now, I don't want to define communication as aggressive essentially, but a good deal...
Pretend that you did, and that's where you ended up with calling what is a right a privilege.
Well, I don't know what I did, but let me suggest why. I would suppose that communication has this intrusive or aggressive side and can very often spill over into what you would then call a misuse of it. But now, I think one gets pushed here to an examination of the fundamental categories in which we think of society, and I think it's characteristic of us when, in a competitive individualistic tradition, to think of society as a kind of Cold War situation.
I'm against that.
Yeah, I am too, but you see, you think of individuals confronting each other, each has his own interests, other people are part of the general environment. He has to deal with them, and you can even describe language in this sense as symbolic manipulation, that you say something, you're understood when you get the right response. And you see the individual entirely using speech as some kind of a tool or a weapon to manipulate a part of the environment, which may happen here at this point to include human beings or dogs and cats who respond to certain ranges of it. But primarily, this kind of manipulative confrontation of one individual against another. A Cold War situation. I would...
Understand you right, Joe? Are you saying, aren't you doing something analogous as regards the social situation to what I said I read you or heard you as doing about speech? Namely, the social situation is what, from your point of view, would be abnormative. That is to say, bad. And the whole process is to purify it and get it better. Admittedly, we, under an individualistic tradition of one sort or another, and certain founding fathers' ideas, we do have, to a degree, and get a competitive version of society. But are you accepting, so to speak, that as normal and saying now the whole effort is to see what we can do, how we can use government to order those natural facts?
No, I take it as something that's pretty pervasive and is taken for granted and which would require a considerable argument, and a very difficult one, to dislodge. But I think rhetorically, if this is at all involved, the problem would be terrible to start with the notion of there is good speech and bad speech, and good speech is that which furthers a particular kind of human relationship, is non-competitive, non-aggressive, is all to be defined in terms of some kind of understanding. The problems of communication, which have to be dealt with now, suppose we say what we're concerned to do is move so far as possible from this corrupt, diseased, or whatever you want to call it situation, to one which would be healthier from the point of view of the notion of a society which is not competitive individualistic. I still want to start here.
I want to build and accept the idea that this is not the outline of a corrupt society, that is this competitive or aggressive communication, but that rather there might be easily discerned a society far more corrupt, in which you had the frustration, stultification of even this level of communication. And that we have a kind of middle ground in which we have the freedom for competitive speech and aggressive speech to take place, however reserving the notion that this is far from a fulfillment of the ends of the political community. In other words, I wouldn't say that this was the model of the corrupt society.
See, I'm a little hung up on the rhetoric now, in the sense that the issue about which rhetoric matters or which rhetoric is best. I do not think, here I may be mistaken, I do not think it's possible to carry on an enterprise in political philosophy and at the same time take account of a particular historical situation in one's own nation and sort of adapt your political philosophy in order to be most influential in that society. There's a certain sense in which, if we were talking political philosophy, abstracting or prescinding or something for the moment, from what rhetoric after one's philosophy would be helpful to influence a particular situation, I think those have to be separated, and I feel that the issue as to whether there's anything consequential in these directions of the rhetoric, if it's posed in political philosophy, I say it is consequential. It makes an awful lot of difference. But if you're telling me, well, I'd rather talk rhetorically as though I'm an orator into a given audience to be persuasive, I better start with the definition they tend to accept.
John?
Well, I wanted to put forth a thesis. I was trying to get around why does Bill's statement about bad speech bother me, it does. And it occurred to me that I wonder if you could say that the right, I have to use the word right here, not privilege. If you could say that the right to free speech, or the right to speech even, derives from the rights of the person rather than from the goodness or badness of the speech, or the truth or falsehood of the speech, which I think would throw us all off if we get into that. And that the problem of free speech is when that right comes in conflict with other rights, which are held by other persons or held by society. Not pleasantness or not order or anything else, but rights. I can think of an example that, libel is an example, where your speech comes in conflict with my right to a reputation. And this is where the problem is created. I'm just wondering about the fact of whether we could really whether we really want to get into a formula where the nature of the speech would be judged. In other words, whether it was good or bad or truth or false or something else, because this gets off into an awful problem as far as I go.
Well, from my point of view, you have if we pursued it carefully, would be trying to get off the thing because you don't like the sound of bad speech. But in fact, in libel, slander, incitement to illegality, seduction to a terrible addiction, and all of those forms of speech, which the law presumably is concerned to curb, sure, they're in conflict with other rights, and it's precisely because the conflict is serious and the damage done is serious that you call it bad speech. And the fact that you don't like the sound of the word bad speech is pure sentiment, as far as I know.
No, it isn't pure sentiment. I would not be dismissed so easily.
I didn't dismiss it. I gave an argument.
All kinds of lies are bad speech in themselves. I'm not ready to go get a policeman to stop everybody from lying.
I didn't say I was either.
All right? So the problem is the right, all kinds of errors are bad speech judged in some objective way.
Right.
The problem I'm trying to get at is why do we say a libel is subject to law and a lie is not, a normal lie is not, or a normal error is not? Why do we say it's all right to tell? We're not going to do anything about a person telling a lie or a person making an erroneous statement. I say because...
If we were pursuing this, wouldn't you ask me whether or not I included under my bad speech making an error in the speculative dimension? I wouldn't, for example, but you're assuming that I would. By bad speech, I would be
Mr.
thinking...
Cogley's trying to answer you.
I am saying that the person's right to speech derives not from what he says, but from the fact that he is a person. Therefore, this is where the right derives. He can say erroneous and stupid and irrational things, and he still has a right to say them, not because they are erroneous and stupid and irrational, but because he is a person with certain personal rights. I'm saying I'm going to do nothing about these personal rights until they conflict with some other personal rights. Then I'm going to have to make a judgment between the two rights involved, and this is the politically prudential problem of free speech, as to which am I going to suppress.
I agree. The fine part of it is we don't have an argument, because I agree with all that.
Right.
That's why I thought your dislike of the thing was sentimental. If you finally end up by saying you don't like it bad, you'll call it harmful. Harmful to another right, which was at stake, and so harmful that I judge that it ought to be regulated, and
therefore I think the question of good or bad speech, interestingly enough, but it is not the essence of the question, insofar as I'm willing to tolerate a lot of bad speech, a lot of erroneous speech, a lot of stupid speech.
You and I are together on that. Let's get that clear.
Okay.
I mean,
Mr. Calvin?
I think that one might say that the interesting thing about the theory of free speech is what you need is a theory that protects bad speech. I mean, the problem is so much really a problem of explaining why we protect so much bad speech that I think his remarks are very close to the center of what the problem is, although I don't really particularly agree on the formula he's using for solving it.
I like I'd like to comment on Harry's remark, because I will not have my point dismissed so easily. Namely, supposing I were to agree, as a student of the legal system, descriptively that your remark is correct, the whole thrust of the theory of First Amendment theory is to see how much bad speech, in some presumably definable, deserves protection. My comment, if we were to pursue that argument to try to preserve my point and my agreement with your descriptive point, would go like this, that I would be surprised if it didn't turn out that the case you made each time for the protection of speech which taken itself you would admit was somehow bad, in conflict with other rights and harmful in one way or another, the case for protection, I would submit, or hope for my argument's sake, would turn out to be based on, and by relevance to, the values in good speech. It would be finally, the protection of bad speech would turn out to be grounded in the reasons why good speech is rightful. Maybe that wouldn't be the case, but that's my outline for the argument.
Well, I think we'll get into this a little more tomorrow, but there is a sense in which, interestingly, that isn't true. I mean, it seems to me that the whole strategy of the law in society here has been to avoid discriminating specifically as to whether the speech in this instance was good or bad. I mean, there's a great point of truth in that as defining the problem and as being a kind of paradox as to why we sort of overprotect it in order to protect it. And I would guess, Bill, that in the instances that we might easily come to, that what all the law says is that some occasions of speaking are potentially more serious, more important, or more useful. For example, it's more important to have members of Congress debate on the floor of Congress and presumably to have us talk about our neighbors. I mean, that seems to me to be kind of a distinction.
I would be surprised if I found out that there wasn't a better case for a certain protection in Parliament. I hope that better speech would take place there, not a mere affection for.
Well, one way of putting the whole thing is that I don't think any theory of free speech has ever insisted the speech be true.
I didn't use the word true.
No, but it's kind of interesting.
Just to get the record straight.
Let's remind that there are some contexts in which I think it's perfectly legitimate to insist on truth, like in the advertising, labeling things. I think there are a whole area in which we do say that it's against the law to tell a lie about how many ounces there are in preservatives, things of this sort.
The distinction between expression and action in this case still doesn't seem to me to have broken down completely. It was just assumed around the table that it was useless. I don't accept the assumption. I see the difference still between speech, which is making an appeal to a mind that's contemplating its validity in some form, and speech which is striking at a reputation of doing various other things. Now, you used the term again. I just want to connect this up if I can. You used the term mind as shared understanding. This is not going to settle this issue, but I just want to get it out in the open. I think if I come back to part of what you maintain, and this is part of our whole dialogue here, John talks about the right of the individual to speech, whereas you put your heavy emphasis, I don't say total emphasis, that would be false, but you put a heavy emphasis upon the nature of speech as a community activity of some sort, in the sense in which speech becomes communication and affects others. What I take as being valid in what John says, and he doesn't have to deny what you say either, is that there is a function which speech occupies in regard to the person in terms of the development of his own capacity, some ideal capacity, which he has, I would use the term again, right or claim to, independent of the effect which it has upon the other members of the society. But your underlying metaphysic, Joe, I think, is very heavily weighted in terms of a certain kind of tabula rasa. I don't want to go that far. This is a parody. But what you continually emphasize, and it's valid as a point, of course, is that the mind is in some sense an artifact which is created by the community. And I think I understand the sense in which that's true. It means at least in part that no mind would develop outside of the disciplines and materials offered to it by a society. A mind left to its own devices would not develop into a mind. That's fine. But the problem about the nature of minds in this case and the relationship to thought is that I take the two terms, mind and mind, as in some sense being self-determining or as having the capacity for self-determination. And consequently, when you talk about the harmful exchange between these two minds, you have to consider the unique function of thought, which is one reason why the continual reference to thought in terms of consequential behavior seems to me to overlook a point. It's a peculiar kind of consequential behavior, thought is, because the two terms in this case have themselves to determine whether the medium which is passing between them is, as a matter of fact, harmful and invalid. In other words, the parties themselves have to determine, in some real sense, the extent of the harm. Now that seems to me to make it rather different from other forms of consequential behavior, for example, like murder or theft, where it's perfectly clear that you can give a definition of whether an act has been an act of murder or an act of theft. The peculiar characteristic of the nature of thought in these exchanges is that to describe the thought as invalid means, at least in part, in most instances, to describe it as harmful, rather, is to describe it in some sense as invalid or false. And the determination of which of these thoughts is invalid or false seems to me to be left properly, at least in part, to the self-determining characteristics of the two individuals involved in the act of communication. That's, I suppose, why I have a different sense of the whole thing from yours. And that's why I would want to protect the notion of false speech, in part because I don't think it's possible to arrive at a definition of what true speech is, even though I would reject the idea of throwing out false speech even if I had a definition of true speech for other reasons.
Well, look, I think I've got to remind you of the broader context in which this occurs. I started out with a concern for the general theory of the government of mind and the impact of our institutions of political action on the cultivation and development of the kind of intelligence that's necessary for our enterprise, whatever it is. I indicated at that time that really the first chapter is the relation of government to education, or the government of the educational process, which I guess would have to be defined as the devices through which we create minds and are concerned with the systematic creation of the mind. The communication is, in a sense, the second chapter, which I presented here. And I don't want to suggest that one doesn't approach the whole problem of the communication, of the government of communication, without, in some sense, a prior concern for the cultivation and development of the minds that are going to enter into communication, and even this is an artificial business. Now, with respect, and obviously a relation between minds is certainly distinct from a relation between bodies, or a mind and a body, or whatever is going to involve. But as to whether or not, because it's a relation between one mind and another, there is no legitimacy in the notion of any control directed by someone outside of that relationship to define what is appropriate communication. Even so, it seemed to me not to follow. And as soon as one pays attention to what the educational relation is.
I don't have to maintain that point, and that's where I think John had a point. You see, his point was, if I understood it, that a conflict develops at that point at which, taking your two final justifications for communication, which you offered last week, you had one in terms of the public good and one in terms of the intrinsic function. Now, part of what I think John would mean by the intrinsic function is the right to speak in some sense. You get conflicts at times because that intrinsic function is capable of clashing with your communal function. But it's not, you seemed to admit that last time, but when you get back into the discourse again, all the weight seems to fall down now on the communal function again. That is, in the interactive sense in which men participate, and not sufficiently, it seems to me, who want to make out some claim for the inherent right in this case, not sufficiently on the use to be served by this speech in terms of individual men, independent of their communal function. John can admit the same fact you want to admit, I think, but to him it becomes a clash between at least these two functions, there may be others, between what you regard as the intrinsic value and the communal value. Of course the speech can be regulated on occasions, but that doesn't solve the problem of whether there isn't also a prior claim to this other kind of speech.
Well, what's the prior claim?
Well, maybe we ought to clear up this point because I've not been satisfied. If you admit that there is an intrinsic value to be served by a certain kind of activity, independent of its effect upon the community, if you hold that there is a value in that, and you yourself used the term intrinsic value to refer to some of these facts, and apparently there was some value there, then it seems to me if you want to reject the word right, I'll do that. I'll use the term claim in a non-philosophical and non-positivistic sense. If a certain activity has an intrinsic value, like the activity of creating a work of art, even if the house burns down and the painting with it and I'm demolished and can never translate it to anybody else, if that activity of creating the work of art has a certain intrinsic value, then it seems to me, I'm not going to argue that it's a priori, there may be steps in between, but it seems to me to come very close to logic to say that if the experience is valuable, the individual has a claim on that experience.
Well, I don't deny that, but look, like any other value, it has to take its chances in a situation in which there are a great many values which have to be provided for, and is thus at least subject in principle to some kind of limitation.
Right, fine, but now the model has changed, you see.
I don't think so.
Well, now, you see, and I think it has, because now you fall back on the language of limitation, which is the classic language. This happens occasionally in the discourse.
Well, I've got two.
See, I mean, that's Emerson's approach also, limitation. You're not permitted to speak on all occasions, you must sometimes be limited.
I reserve that for what I take to be one of the two major claims to freedom. One is the claim which is associated with the powers you need to perform the function. That is to say, I need this freedom in order to perform this function, which is, in a sense, a necessary one. And it's for that. then I suppose the granting that there are activities, there are things which we pursue or do or value, not because they perform a function, but we pursue them because we value them for themselves. And I said the justification for freedom here is not the justification that you can give because it performs a function, but the justification in general utilitarian terms. Namely, this is something that satisfies some desires or interests or is good, and the scope which it is given has to be determined by not the performance of the function necessarily, but certainly it's regulable in terms of its impact on others.
This is rather important now, because now you've granted, you have previously, two justifications for the speech. It's not simply that society grants the right of the speech in the privileged sense.
That doesn't follow. It grants the right.
That's part of it. But in the other case, it's dealing with limits, not with grants of rights. Well, as I read what you just said, you admit that that there is a claim to this kind of activity because it's intrinsically
yes,
good.
But now that claim doesn't mean right by itself.
No, but now how does the claim get controlled socially? Its limits get defined, isn't that right? Society doesn't grant the intrinsic value of the act. Society has a right to strike down the limits of the act when it conflicts with other values.
For something to have something to be valued by somebody doesn't by itself create any rights at all. We create rights with respect to it when we define the limits of its protections and its possibilities. We say it can be carried on under these circumstances without any interference, or it can't be, or it will be protected.
But when society says it can be carried on under these circumstances, it's saying so because it has discovered something and not invented something.
But it hasn't discovered a right, it's discovered an activity which people value and which it then surrounds with the structure of rights.
I'll drop the term right. It's discovered a valid claim on an experience.
Valid claim? I don't know what a valid claim means.
Well, if the good is intrinsic, isn't the claim to it valid?
I don't know what that means.
Well, I don't think valid is any harder than intrinsic, is it? I mean, this is a kind of disingenuousness, isn't it?
No, I don't think so.
Does anybody want to get into this fight?
Yeah, I'd like to get into it in one way. It seems to me all these terms are so related that there is no real distinction between good speech and bad speech, between rights and duties and aggression and control and whatever the opposite is. Now, this, of course, would be merely a metaphysical suggestion if it weren't for the fact that there's a vast body of literature in all subjects, speaking of communication, which makes it necessary to throw out some of the terms of the discussion, not throw them out, but to reinterpret them. For example, in psychiatry, the big noise today is passive aggression. Now, if you understand aggression as something active, it would be a mere contradiction in terms to talk about passive aggression. And this in many other fields. Well, what's the consequence of this? Well, not as a mathematical discipline at all, but as a philosophic one. You have a whole theory of communication. And in this theory of communication, communication is understood as control. But I think this word is misunderstood and has led many people, perhaps Mr. Tussman, to think of control as being something just purely aggressive. But control is not understood by the philosophers of communication as something which is aggressive. I'm trying to give an example here of this dialectic as it seems to work out. It's not only active manipulation, it means exactly the opposite also. It seems to me that the active and the passive aspects of communication mutually imply each other, and a similar systematic dialectical ambiguity attaches, I think, to all the terms of this discourse, rights versus privileges and so on.
Mr. Ashmore?
Well, I've been having the same trouble that Mr. Wilkinson stated with the ambiguity of these terms. Mr. Wilkinson, as usual, compounded my difficulty, but he stated it very well. If I'm understanding the terminology, the political community on which you lay stress, you wouldn't need a First Amendment. You wouldn't have a free speech issue, it seems to me, except for the quality of aggression that is involved in the political dialogue.
Huh? Kind of goes in with Harry. I was trying to find a formula for what I'm trying to say. And what I was trying to say was that the essential part of every free speech case is the protection of a right, which is some other right. If there's no protection of some other right involved, then I don't think you have a free speech case. And therefore, I would judge the case by how important is the right being protected by this act of suppression, if I can put it that way. It's kind of a negative way. Say, is the right by which the suppression is justified, the protection of the right by which the suppression is justified, important enough to suppress the speech, to suppress this other right?
That's the balancing doctrine, I take it. But remember, on the classes of rights which are involved, if I may respond to that, I start out by talking about communication which has aggression against a person, and then I listed the whole bunch of traditional ones. I also suggested there was the notion of aggression against an institution, and induced things like seditious libel and blasphemy, and aggression against assault on some sort of taboo, under which I would subsume things like the obscenity problem. But what your suggestion is that in every case, I take it, every free speech case involves.
I'm not saying every. I would like it to be that way.
Or that when we do have a free speech problem, it's because some kind of communication activity has impinged on one of the areas which we think in some way or other needs to be protected against it. And my argument...
Protected against free speech, but I'm sorry. That's
what?
The point. I haven't said it right. That I'll try to give this example. I have to come back maybe to libel as an example. I have a right to my reputation. And this right comes in conflict with your statement about me. Now, I say when you are suppressed, the essential act that is being performed, the way I want to look at it in any case, is not so much your suppression as the protection of my right to reputation. In other words, I want to accept the positive side here.
Surely it's both together, though.
Well, sure. One follows as night to day and all the rest. But what I'm getting at is if the essential positive act is not very important or very good or trivial or something else, then I don't think it justifies the negative aspect of the same act. In other words, the suppression of the speech. I'm trying to find a standard for myself by which I can judge.
Well, I don't know if that standard resembles the typical Frankfurter thing. On the one hand, we have the desire of the government to provide for security. On the other hand, we have the interest of the individual in expressing his judgment, and what we have to do is weigh the harms.
Problem, isn't it? Isn't that what the problem is? You may not reach Mr. Frankfurter's conclusions, but at the same time, isn't that what the problem is? Otherwise, there wouldn't be any problem.
Mr. Calvin?
May I make two comments? One directly in response to John, then something I wish to say earlier that isn't in response to. In some ways, John, this is the clear and present danger talk again, because the formula, whatever its shortcomings and so forth, focused on there being somebody pointing to a clear, specific, substantive evil that was being threatened by the speech, and you were protecting some interest from that evil. Now, ironically, it is in the big discussions of this, I can only recall one opinion. It's an opinion by Brandeis in which the question is ever raised as to whether there's some gradation of evils. I mean, does the evil have to be serious as well as being urgent?
Again, I wouldn't have put the clear and present danger, and the community has a right to be protected from this danger. That's the theory, isn't it?
Well, whatever the evil is, I mean, whoever is endangered by the evil has a right to be protected from the clear and present danger of that evil being generated by the speech. I mean, that...
Well, all I'm trying to get at is if I have a free speech case and I'm trying to outline what is the issue I face. First of all, I want to find out what right I am protecting by suppression. Now, I can make all kinds of mistakes in judging this and prejudices and everything else, but it seemed to me that is the essential thing I'm doing when the issue comes up. And problems I might have is that there really isn't any right I'm protecting. I end up protecting no rights that were really threatened, in which case I might be critical of this or that justice, because he really wasn't protecting a right that was really threatened or something else. But it seemed to me that's the anatomy of the problem.
Yeah, what I was saying is that the history of the constitutional development here is interesting in those terms, because the thrust has been to try and protect speech strategically by a constitutional formula which said it's got to be really threatened, and we mean really threatened. You've got to show almost an immediate threat of harm. People always overestimate the threat. But they got so preoccupied with the proximity of the speech to the danger that they never worked out any calculus of the magnitude of the evils that were being threatened. And
Are you just reporting this, or saying that the law was wise on this point, or wrong on this point, or it's unclear?
I'm just reporting it, and I think it was unwise, although not as unwise as it may have been thought to be later. I mean, there's certain elegance about that formula in some ways, in a way that comes rather close to your terms. Can I come back to the point I was going to make before I was distracted by John's comment? This is a question to Joe, which would be to tie your position back into the controversy that was going on about 15 years ago about preferred position. It seems to me, I think I could sympathetically state what now seems to me to be your position in those terms, as that the controversy was one of whether speech had a preferred position. This is a constitutional law controversy, but I think you could take it out of that context. Whether speech had a preferred position among freedoms in terms of the constitutional routine of estimating regulations of it. And for a little while it looked as though the court was holding to that theory, and then there was a great deal of criticism and so forth. dropping the constitutional form of that, seems to me one could ask whether is it a necessary condition of a theory of free speech that accord distinctive protection to speeches against other conduct. That's been the tradition of theories about free speech, that somehow it gave distinctive protections, preferred protection. It was protected more than other kinds of conduct would be protected in some honorific sense like that. It seems to me much of the argument that's been going on between Lichtman and you and Emerson and you and so forth really relates to this, and between Bill and you. That I take it what you really were basically saying is that speech is consequential, not aggressive. That seems to be a better word for you than aggressive. Like other conduct, it's consequential. Therefore, there is no distinctive reason for not exposing it to regulation in the sense that any other consequential conduct would be regulated. I mean, it's not entitled to a preferred position because of some intrinsic mind-body separation or some intrinsic value in speech itself as against other kinds of activities.
I don't like the notion of the preferred position thing had echoes of controversies which weren't altogether bearing on this. I would argue that speech needs the protection which is appropriate for it.
But that's like everything else.
That's right, like everything else. But what is appropriate for it turns on the particular function that we rely on speech to perform, and it needs that kind of protection. It also, as an activity that you want to consider, an activity of human individuals, quite apart from the performance of that function, I do agree that there's a different kind of rationale for that. Now, remember Alec Mickeljohn's general view here makes the distinction between public and private, and he uses the fifth and the first to say there's a certain kind of speech which we have decided, by interpreting the First Amendment to mean the political speech of a citizen, has a degree of protection which is not enjoyed by that other kind of speech which in the Fifth Amendment or in the 14th is part of the liberty protected by due process of law. He thinks there's a difference between saying you may regulate certain things by due process and you shall make no law abridging at all. And his attempt to deal with, to save meaning for both of them so that they don't simply cancel each other or throw one of them out as redundant, is to say they're referring to different kinds of things, and it would pretty well fit the two rationales.
Well, let me rephrase my question, which I think goes to the group. It is whether one can meaningfully discuss a theory of free speech without discussing some companion theory about something else against which you're contrasting it.
Like what?
I suppose the economics or anything else, you see, but it seems to me that what the mystery here is, are we talking about the way we regulate any conduct we're going to regulate, or are we talking about...
Fourth Amendment doesn't say Congress shall make no law. The Fourth Amendment says that Congress shall, or that the law shall sanction no unreasonable invasion. The same is true with the Fifth. It isn't a prohibition against taking property, it's against taking property without due compensation.
Sure.
So that the question that I think Harry's getting at is indicated, is reflected in these three amendments.
Can I just repeat the question to you, Joe, the same question another way, making a kind of indecent appeal, not indecent, but an appeal to what I think is another mode of your thought, largely in the book on political obligation. I would have thought reading that book, that in your mode of analysis, which neither pejoratively nor anything else is Kantian at a certain point, admittedly so. In this sense, that I take it, you say that taking the democratic enterprise as given, the binding quality of certain obligations is derived analytically by the implications of the enterprise. You said in your discourse last week here, when you were trying to say, how do I get appropriate system of protected opportunities for communication? Appropriate, most of them I will get analytically from the nature of the enterprise and the notion of a system, etc. Now that being the case, I'm now returning simply to Harry's question, trying to appeal to another mode of your thought. When you are pursuing your analysis and saying, I want to derive analytically out of the very notion of the enterprise itself, those necessary conditions for the real prosecution and success in that enterprise, wouldn't you come out with speech as being more essentially necessary, a certain kind of protection for speech as more essentially necessary to success in the enterprise than other things like the right of private property or the other things referred to, in which case, without the associations of the notion preferred in the legal controversy, in some sense or other, speech is preferred in a grounded way by the result of your drawing it out as a necessary analytic implication for the enterprise. Wouldn't you in some other mode say that? Here, however, you replied to Harry by saying, oh no, it's like other things in the sense you have, mutatis, you have to find the appropriate mode for its regulation, but it is not, on its face, less worthy of extra caution about regulation than any others. It's just a question of varying the appropriateness. don't you, in two different modes of thought, tend to give two different answers? One you gave to Harry, and one I'm trying to say you would give in another mode of thought.
There's there seems to be an unfortunate ambiguity in the term balancing. It's one thing to talk about balancing in a particular case, which is the way it's usually formulated. Here we have this case and we have these conflicting interests of the individual and the state. Whereas there's quite another approach to the balancing problem, and that is precisely this one of saying, how are we going to balance off the interests involved in a class of cases so that we can then come to some conclusions as to how much weight we give to what attributes of due process in a criminal proceeding. Because here we're putting a guy in jail and not just fining him, rather similar reason. And the balancing process is the process by which you come to a theory regarding what is legally significant for this type of setting. And it's not a matter simply of dealing with the specific facts of a particular case.
Both Black and Michael John have spoken in some senses sympathetically of this kind of balancing in their phrase that the founders already balanced when they wrote the Constitution. That's a phrase that appears fairly often in their work.
Well, yeah, of course, balancing has some difficulty, but I don't think, Phil, that the entire burden is borne by substituting a class of cases for a particular case, because I suppose the only reason we're really interested in particular cases is that because they are, for us, the representatives of classes of cases.
Yeah, but the whole case approach tends to undermine the quest for generalization regarding types of settings.
Let me, just on the balancing, I think to the extent that that's legitimate, look at the different situations which are dealt with. There was an interesting class of cases we haven't dealt with here, but Craig versus Harney, Pennycamp. That is where you have contempt of court. A newspaper will write an editorial while the judge is still trying to figure out which sentence to give, and says if he doesn't send these crooks up the river for as long a stretch as possible, we'll take care of him at the next election, where he was subject to an election. So here, when you say now you have to balance, is this freedom of speech, freedom of the press? Can't the newspaper man say whatever he wants? Or the Bridges telegram was another case. We'll tie up the country if the injunction issues or something of this sort. Now, what you have clearly in conflict is the right of a person to a fair trial, which includes an uncoerced judgment by the judge, as against the right of a newspaper to comment on a matter of public interest, and the questions of how you balance these two public concerns. This is one sort of situation which has been dealt with. Now take another balancing thing in which I've always felt the balancing, had it been done properly, except you don't state it in these terms. Take the congressional investigation problem, where what you really have to balance is the desire of Congress to get a hold of information which it regards as relevant to the performance of its own function, and I'm willing to grant at this point that it might be relevant information, against the desire of a member of the electorate to preserve the vigor of his branch of the government by asserting a privilege not to reveal in public the process of his own intellectual activity and interchange, for instance, if they're asking whether he advocated something. Now, what you have to balance here is what is needed for the effective functioning of the electorate as against what is needed for the effective functioning of Congress. And you might, in terms of the balancing, when you say that balance has been struck already, simply mean here that there has already been a hierarchy established in which Congress is subordinate in the hierarchy of political institutions to the electorate.
But not necessarily in such general terms. Well, one could say that for purposes of...
Maybe, but at any rate, this is another balancing. Or, for instance, you get this problem where Congress wants the information about who in the executive branch of the government made this recommendation which the President acted upon, and have interesting problems about... or the sound truck. I want to announce my meeting or sell my product or announce this, and the child, the parent who wants the child to be sleeping from 2 to 3, in which case you have a conflict of interests which don't involve, let's say, political tribunals and their powers. Now, to say that all of these are problems of balancing, well, apart from the very fact that the notion of balancing is in any sense a physical metaphor which I think has never been worked out in satisfactory ways to deal with any of the problems, it's just a terribly misleading one because no one does the balancing. It's an entirely different intellectual process. And to talk about weighing, what's notorious about all those cases is they say we have to weigh this against that, and then they never do it. Or they never show you the process by which one would intellectually do anything of this sort.
Could I try again to get myself off the hook on balancing? I never wanted to propose balancing. My notion is that there are prior rights, there are superior rights, and so forth. In most cases,
it's possible to figure what they are.
Well-
And that guy wins.
Now, how does it fit with appropriateness?
Well, I think the question of appropriate here, I would suppose the appeal to the right, to the trial and the others never seemed to me to raise an issue. The appropriate question is, should a decision be criticizable? Or should it be interfered with in the process? And it seems to me that all you have to do is say there are time, places, and manners. There is some adjustment. You hold your critical fire until after the decision has been made. I find no abridgment of freedom of speech significantly in the British conception. Just as a practical arrangement, which saves, as a matter of fact, both, which allows the complete right to criticize and subject the decision to the judgment of the community in appropriate ways, without interfering with the right of a person in that situation to get his fair trial, and to insist that I have the right to launch my criticism in a form which interferes with the tribunal doesn't seem to me to raise any question except to traffic one.
All right. Could I get somebody to speak responsibly to my very simple question? Is the purpose of this philosophical exercise granting the fact that we have had to establish some kind of limits upon aggression in communication? Is the purpose of the exercise to see if you can eliminate the aggressive quality of communication, or is the purpose of the exercise to establish some kind of standards of aggression which would be recognized and protected?
Well,
What do you mean by aggression?
Well, let's go back. I have a definition which is very satisfactory to me, and that is that...
first of all, I'm not... Well, okay.
Fine. Joe's the one who's
I'm not
using it.
interested at this point in using the theory of free speech to come up with a device which will eliminate verbal aggression, but rather to provide some acceptance of the fact that, and a deeper understanding of the problem of verbal aggression, and get us to develop appropriate forms of permission or control. That is, in some sense, one can argue that verbal aggression is a moral equivalent of war, or at least a less destructive one, or maybe it's a more destructive one. But at least at this point, I'm not interested in using this theory to eliminate this, but to suggest that the problem of freedom of speech, I'm very dissatisfied with the general state of, we've got a freedom of speech. What does it mean? You can't do this. It reduces most of our position activity to something we have to do with a sense of guilt and without much understanding, and as if it's an anomaly, and that most of the time the theory is if a person is engaging in verbal activity, somehow that has some kind of a natural right to be permitted. Now, if you ask whether beyond that, I think a proper use of speech or a proper system of communication would be less aggressive in character and more collegial, I would say yes, that the aggressive corruption of human communication is one of the bills which I put very heavily on the shoulders, among other things, of the free enterprise system of life, or competitive individualism. And I think a good society would have less of this, although I'm not obviously using these notions, which start from where we are, entirely as directed at eliminating these.
Well, thank you. I think that does answer my question. I gather you answered that your exercise was the second one I cited, to set some kind of reasonable standards and some degree of protection. Michael John's last statement before he left, and we talked about it a little before, is probably, I think, relevant here. He said that he was concerned, I think he said it to the table, with the way that the whole conversation seemed to turn on the protection of the individual who has exercised his right of free speech, rather than on the community good that comes from the proper exercise of free speech. And this seems to me to be a recurring theme here, too, the idea of getting protections, to use that word, or immunities, which relieve the person who's exercising his right of aggressive free speech of any undue penalty.
Well, but I think that's not quite the way to state it. The problem is always to relieve the individual of some of the penalties or some of the consequences of aggression, not entirely because we want to relieve him of them, but because the function won't be performed unless he is relieved of them.
By providing such relief, you then encourage a freer dialogue.
You encourage the proper, the wiser, more effective performance of the function by people who have to speak in ways that may otherwise subject them to consequences. Now, if one also wants to say that there's something like the self-help notion that in certain areas we don't want to deal with, we want to create a situation like picketing which we'll tolerate, in which we recognize this is a form of warfare, but we draw limits. We say it's all right to fight this way and far better to fight this way than some other way. and the drawing of the bounds of permissible warfare, which happens to take the form of verbal warfare. It seems to me we do this all the time. The whole theory of free competition is full of, as well as picketing, full of rules of how you can attack and how you can't encounter verbal competitiveness. Now, I'd like to say one more word, if I may, on these two relationships. Once, when I was teaching in the speech department at the University of California, the question is, what kind of speech are we supposed to teach? I mean, what are you supposed to teach them to do? Students would often come to us with the notion, and it always reminded me of as if they were coming to the sophists in Greece with the notion, here we have the power of rhetoric and we'll give it to you, and what you will be able to do with it is it's a form of power, obviously, and you can then succeed in what you want to do. You can take advantage of the community, you can get what you want. My answer always used to be that it didn't make sense for me to suppose that the taxpayer was paying me to teach them how to take advantage of the taxpayer or the citizen.
Well, you're undermining the whole foundation of the law schools of America.
Well, I'd be glad to do that in passing this way. But in order to develop this point, we were driven to a distinction between competitive and collegial speech. And we pointed out that when they had the model of speak, and it's a very attractive one, supported by all sorts of general theoretical positions, that the individual is here peering out at the world and he thrusts out a finger or he moves his tongue and gets a signal going and he gets the response, and that it's a kind of solipsistic view of life. But there he is hurling these signals which get certain responses and sees him all alone, the whole world, as material for him to manipulate. We tried to point out, or at least I tried to point out, that this does injustice to any kind of fellowship. And when you get the collegial relation, for instance, I remember once being very fond of the contrast I was making between the kind of communication that went on in an insane asylum. That a certain kind of communication went on between the staff and the inmates. That is, if somebody insisted that he was Napoleon and you wanted to get him inside, you might say things like, Josephine is waiting. I mean, this sort of thing.
How'd that work?
Pretty well. But that you would be horrified. Yeah, but you'd be horrified if the staff, in trying to determine what kind of treatment they should adopt for the patients, would use these same manipulative techniques on each other. I would hate to be the victim of a medical consultation in which a doctor who just wanted an operation, wanted to try this operation, was using his salesmanship in order to get somebody else who wanted to try a different course of treatment. And you hope at that point that something else is going on, and that a kind of collegial communication doesn't have the same form that this warfare. And it seemed to me, now the question is, how do you apply this to the democratic and political one? It seems to me we're pretty well corrupted generally by the notion that a democratic society or political order is one in which everybody uses all of the instruments of language, so far as it can, in order to get what he wants in competition with somebody else. Whereas it seems to me the theory of democracy at this point applies to the political institutions a collegial conception, and says our appropriate relations to each other is, so far as communication goes, is one in which we're trying to discover what is the best thing for us to do in the light of this common problem, and that to corrupt that into I want this, you want that, and then bargaining or various forms of warfare makes the whole thing pointless.
In this notion of the congenial, if we can just get back to good rhetoric, a kind of fraternal situation of speech, isn't there an assumption in some sense that what the parties can come together upon and agree upon, and what in some sense eliminates the necessity of their violence, is the fact that there is, in quotation marks, the truth which they can arrive at, or there is some procedure at least which they regard as being valid, which they can make use of in the process. They're left in a sense with violence when they have nothing else to oppose to each other except their own passionate commitment, let's say, to a kind of private sphere, which neither of the others can be made to accept.
Yeah.
But isn't it wise then also, obviously, to be aware of the fact that the human condition being what it is, and putting aside the kind of Marxian assumption that the evils of aggressiveness lie in the socio-economic system and not somehow or other in the nature of men, to some extent, isn't it conceivable that one ought to keep aware of the fact that since it's not likely that this kind of common interpretation of what the central focus is upon which all of them can agree upon, that since it's not likely that you are going to get conviction as to what that particular truth is, again in quotation marks in this case, that there's always going to be an intrinsic amount of combativeness, if you want, that stems precisely from the fact that the view of one individual is in some sense opaque to the view of another who is not convinced by the view. I mean, again, if I come back and press you on what aggression means, I didn't mean it facetiously before, it's not clear. I think that's one reason why you had some difficulty with the idea of aggression, and you went from aggressive speech to consequential speech. Now, consequential would be safer.
Consequential and indicated that I don't know why I'm always kind of being put in the... I said it's consequential, and then I began to stress the aggressive aspects of it, or the intrusive aspects, which led to the obvious notion that it was subject to control all over. But go ahead.
But obtrusive, it won't do it by itself, because any speech that's consequential is in some sense obtrusive. That is, when you speak, it affects me. If that's all that's meant, that doesn't get to the heart of the doctrine. If I take a ploy out of contemporary language philosophy, and I hope it's the last one I ever have to make use of, if you've got a term like aggressive on the one hand, then apparently you have some definition of non-aggressive on the other. Now, it's not been clear, though, from the discussion what non-aggressive speech would be in this instance.
I'm damn confused. If I, in a nice, sweet, naive way, offered the following distinction, what would be wrong with it?
All right.
Persuasive speech is a speech which hopes for assent from the person that you're addressing, but hopes that that assent will be made freely. By freely, I mean made in the light of things seen by the person to whom you've been talking in his own right. To be sure, as a result of things you proffered him or put before him, but when you hope to persuade a man, you hope that he is free when he assents. When your speech is aggressive in intention, you couldn't care less about whether or not it will be free, voluntary, made in the light of things seen by him. You hope the assent will somehow be more one of the will and only sort of apparently through the mind. Now, this is what I think any sort of person would have in mind in saying, well, there's a man who speaks to me persuasively, respecting the freedom of my own mind and the value therein, and here's a guy who's trying to bully me into some sort of assent to what he assents to.
Well, if the argument were as simple as that distinguishing between intellectual consent freely granted in some sense and that of bullying, I think the problem would be over. But since there's a whole intermediary realm, I mean, if it were that simple, I can't conceive of how it would be.
Why isn't it
But
that
since the
simple?
terms freely given, intellectual consent, are to me very largely ambiguous, it doesn't help me very much to introduce them, is all I can say.
The aggressive argument on behalf of non-aggression.
Well, that's what it's meant to be. Let's, on the point of simplicity and complication, let the one thing be clear. I say this distinction is simple and in the order of reason to make. I am not thereby involved in thinking that the purity of this distinction can be realized in actual fact, or that any particular exchange between two men perfectly exemplifies the persuasive definition, another one perfectly aggressive. I would contend that there are very few situations in which the norm involved in a definition of persuasive speech is ever in fact enacted.
You have been listening to the fourth and final discussion to consider a theory of the First Amendment proposed by Joseph Tussman, professor of philosophy at the University of California at Berkeley. Participating in the discussion were the chairman, Robert M. Hutchins, Harry Calvin, Jr. of the University of Chicago Law School, Philip Selznick, chairman of the Center for the Study of Law and Society at the University of California at Berkeley, and staff members Harry Ashmore, Richard Lichtman, William Gorman, John Cogley, and John Wilkinson. This is Halleck Hoffman speaking from the Center for the Study of Democratic Institutions in Santa Barbara.